Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Erica Adler, shareholder and leader of the Healthcare Practice Group of Retzel and Andrews. Today, I'm here with Mark Kalish, shareholder and member of our litigation group, and we're going to be talking about the Telephone Consumer Protection Act, or the TCPA as it's called. Now, this may seem like a topic that doesn't relate to healthcare, but you would be wrong, because in fact, many of our healthcare clients are getting caught up with this act, which impacts communication they may be having with patients in the form of text messages, emails, and other communication that may not be compliant with the law. So Mark's going to fill us in with a little bit about some of the situations we're seeing, how you can protect your practice, and what to do if somebody tries to accuse you of violating this law. So thanks for being here, Mark.
Thank you for having me, Erica. So the Telephone Consumer Protection Act, which is commonly abbreviated as the TCPA, is an act that's been around for a number of years and goes back to the time when people had old-fashioned fax machines, and advertisers would send advertisements to fax machines, and the government and the Congress legislated against this because they were concerned about the fact that the advertisers were using ink of the consumer, and back then, particularly fax paper was heat sensitive and rather expensive, and they were offended by the fact that advertisers were switching the costs of advertising onto the consumer and also tying up fax machines, which back in the day when people used fax machines were a critical part of a number of businesses, and they would get tied up by being inundated with faxes. So the Congress enacted Telephone Consumer Protection Act, which has very stiff penalties for violations of the receipt of, originally it was faxes or telephone calls, and it's been expanded to unauthorized robocalls, unauthorized text messages that are received by a consumer advertising goods or services. And the thing that makes this act particularly dangerous if it's violated is there is a statutory $500 per violation fine, which means that if you send out to one one text recipient or one consumer 100 text messages over the course of several months, each one of those violations, there's a statutory $500 fine, which the courts can't reduce. So very quickly, these claims can add up very significantly, particularly if you're making technical errors, which are you're sending mass emails or text blasts to large groups of people in order to garner patients or to sell particular services related to medical care. So you have to be very careful, and it can be very costly to a practice or to a business. And there's a component of these cases where they're easily turned into class actions. So if you're doing broad-based marketing, people that are not your patients, and advertising goods and services that need to have prior express written consent for in order to engage with them, and you violate it, you could be subject to a class action that could be hundreds of thousands of dollars or even millions of dollars.
Okay, so
So
let's summarize here. So basically, what I heard you say was that contacting people who are not your patients, you can encounter a fine for every single one of those contacts. All right. And this could be something that you end up getting sued for or hooked into part of a class action lawsuit. And the judge, even if the judge felt bad for you, would not necessarily be able to alter the number of fines because it's set by statute. So I don't know how many of our clients are out there, and they're probably thinking, well, I use a service that does all this for me, and they're making sure they comply with the law, so I don't have to worry about it. Or the second thought might be, I don't email anybody but my own patient, so I don't need to worry about this. So how do we think about those two areas?
First of all, The vendor issue is particularly dangerous, and we've dealt with a lot of practices and companies that have thought that they hired competent marketing companies, understanding that this is a complicated area and you have to act properly. And then it turns out that their vendor is not following the rules under the TCPA or is not keeping accurate records to prove that the parties have an existing relationship and that they've consented to receive the fax. And then there's all these rules about having ability for people to opt out. So sometimes the vendors don't keep an accurate opt-out list. And so they continue to send faxes after people have typed in words like stop. Sometimes people will type in a word and it doesn't trigger the electronic mechanism to take them off the list. And then you continue to send them text even after they've said stop, which is even more problematic. And then we've had our physicians or other companies go to the vendors and say, well, the agreement that we had is that you were going to deal with the TCPA and that you would not send any unlawful faxes or phone calls or texts. And the vendor comes back and says, well, we complied the best we can. If you read the fine print on your contract, you're supposed to be monitoring this information. You're supposed to make sure that it's compliant. You have to indemnify. Again, a lot of their terms and conditions aren't even in a formal contract. They refer you to a website where their terms and conditions are, and they actually have the party that's hiring them be the indemnitor of them, because they say you're supposed to know who are your clients and if they've opted in or opted out and all this other things. And so a lot of times our practices have relied on these vendor relationships and they've really backfired. And then you try to bring them into the lawsuit or try to sue them after there's a big exposure, and you find out that number one, they're just a computer server in some Caribbean island, or they're offshore companies that are behind a million shells for this exact purpose, because they take in a lot of money on a monthly basis in these subscriptions, and they don't do what they're supposed to do, which is carefully monitor who's receiving the faxes. So that's one of the primary things. If you're going to use a vendor, you need to be very careful about language of your contract, who indemnifies who in case there's a violation, and who is the guarantor that everything is compliant.
Okay, great. So, that's a piece of advice for everyone out there. If you signed a contract, make sure you know what it says. If you don't have a contract, make sure you get one. And if you haven't been staying on top of this, even if you think you've contracted out a responsibility, at the end of the day, it's always going to come back to you. So really, you need to be the one that's on top of it. So that's part one. Now, assuming that you have your patient list and the only people that you're texting or emailing are your patients, are you always going to be safe?
Well, I think there's a couple things that you can do to ensure that you are in full compliance. And it starts really at the intake of the patient. So just like you have your HIPAA forms and your other required privacy forms and insurance forms, you should actually have a form that is designated to get express consent from the patient to communicate to them both by phone and by text. I mean, I don't think people are really using faxes anymore, but so at least those two modalities, you should have them identify the actual number that is acceptable to receive texts, because texts seem to be the real hot point right now. A lot of practices are using text in order to confirm appointments and to establish appointments, and also to give general reminders related to like annual physicals or dental procedures. And so I think it's very, very smart for every practice to have a policy where they actually have a piece of paper that's signed by the patient that identifies an acceptable telephone number that can receive faxes, and that they've consented to receive any types of faxes. I'm sorry, I keep saying faxes. Any type of text that the practice might send. Then the other way to be very sure that you're in compliance is under the TCPA, the FCC, which sets out a lot of regulations under the TCPA, has created a healthcare rule which exempts a lot of activity by healthcare providers that other companies would be actionable. But there's a lot of specific conduct of healthcare providers that are exempted from the TCPA. So the healthcare rule defines healthcare as care, services, or supplies related to the health of an individual, including preventative, diagnostic, therapeutic, rehabilitative, maintenance, or palliative care, and counseling services, assessments, or procedures with respect to physical or mental condition or functional status of an individual. So if you have an existing patient relationship and the healthcare service that you're providing falls within that definition, you're exempt from the TCPA, meaning you can send text messages regarding healthcare services, and you would not be potentially liable. The problem is you need to be within the definition of healthcare service, and there's a lot of ancillary products and services that are provided by healthcare providers which fall outside. For instance, in the dental context, there certainly would be a gray area as to whether cosmetic teeth whitening or other cosmetic procedures, veneers, and things of that nature, whether that would fall under the healthcare exemption or that would be a product or service, and therefore it would require that you comply fully with the TCPA.
So
Also,
wait, Mark, just to clarify, like if you're reminding somebody that they had an appointment to get their teeth whitened because they made the appointment and everything, you'd probably be okay. But you're talking about out of the blue, you have a patient and you're just like, hey, why don't you come in and get your teeth whitened at 10% off or something like that? Is
well,
there a
so
difference?
I think it's an interesting question because for sure, an appointment for a dental exam that would fall under the healthcare rule and would be exempted. An appointment to have your teeth whitened could arguably be a cosmetic procedure that doesn't fall under the criteria of healthcare service, and then that would be outside of the exemption. Then you'd have to comply with all the other requirements of the TCPA, just like you were a car, an auto shop advertising a tune-up or which would be actionable. So I think that again, it's these gray areas. Also, like for instance, if you were a dermatologist and you were advertising hair removal, or saying that there's appointments available for hair removal, laser hair removal, something of that nature, you would be in a gray area there as whether that's a health service or that's a beauty service that would be actionable. Similarly, if you advertise, like for instance, you're coming into the summer, you're a dermatology practice, and you say we're having a discount on our best dermatological sun tan lotion or things of that nature. Those would be outside of the healthcare classification. It could be. It's a gray area. I think there's an argument that it is healthcare related, but it could easily be argued that it is not, and that could be actionable, and you would be subject to all of the requirements of the TCPA, which there are a lot of requirements to meet in order to send that without prior express consent. I mean, you have to have prior express consent. You have to have an existing business relationship. You have to have the ability to opt out, and a number of other criteria in order to send that if you're not exempted under the healthcare. So there's a lot of gray areas that need to be looked at.
Right. And I mean, I can tell you just as a consumer, I get texts all the time from places I've never been promoting services and items that are pseudo medical in the sense they're like aesthetic related in particular or something like that. So if I'm receiving them, others are as well. I guess the question is, those savvy people out there who are getting these and realizing that there's a law that prevents it are actually going and talking to lawyers. And many lawyers out there are becoming aware of these types of violations and they're commencing class action lawsuits. So quite a few of our clients have received notices of lawsuits, class action lawsuits being filed against them for this kind of conduct. We've become involved in quite a few of these cases recently where we are working with our clients to determine, what kind of safeguards did they have in place? What kinds of texts were they sending? Did they honor opt-outs? Were they relying on a vendor? Were the services of the type that are medical or dental or non-medical or non-dental? And so this is kind of an analysis that we've been doing for a lot of our clients. And I can only imagine that there are many healthcare providers who are getting caught up with what is really becoming a trend in terms of class action lawsuits that are happening nationally. And I know you're seeing quite a bit of this as well.
Yeah, we've seen particularly with uh, um, use of physician practices and dental practices of text for for appointment scheduling, but then you start using it for other things in order to try to increase volume, traffic, physical exams, yearly physical exams, and then also products and services. And a lot of times you go off into like one of these gray areas, and they become actionable. And also there's a lot of other kind of weird situations that can occur. For instance, we've seen cases where the phone number that's used for the solicitation is actually the mother's of a minor child. Well, the argument is that the mother is not a patient of the practice; the child is. So, is she then exempted under the TCPA because there's an existing relationship? Because there always has to be an existing relationship and consent. And so that's been issues. There's been issues where over a long period of time, somebody terminates their phone number and the phone number gets picked up by somebody else. Now, this is something that is very difficult to prevent against. But again, good maintenance of records, like, updating these forms every couple of years to make sure you have their current phone number and that the consent is still valid is important. And another thing that's important is if you look at the regulations, you'll see that you're supposed to have the ability to opt out and you're supposed to keep opt out lists. And we've seen a lot of people, a lot of practices that are generally complying with the rules, and then they get someone that sends an opt out, and they're not maintaining their opt out list. They continue to text that person over and over again after they have opted out, and this creates a significant liability. And then once the plaintiff's attorneys get a hold of these cases, they look at it and say, oh, they have a practice where this person clearly opted out. They're not keeping an opt out list. And then they start going after you on a class action because if you did it to this one patient, if either your software malfunction or you're not maintaining the list properly or your vendor has messed up, then they go after you on a class action because it's highly likely if for one patient opted out and you didn't respect the opt out that you're probably doing it for a lot of patients and they like to go after you for class action, then the numbers add up very quickly. And a lot of times there are also software failures or times when you're upgrading software and there's periods where it's not cross-referencing the opt-out list and text slip through and go to patients that have not requested them. If you have a large volume practice, you could be sending a lot of unauthorized texts that are actionable, and it could be a very serious issue legally.
Now, is insurance cover these kinds of claims? So is this if you get fined for X amount or there's a lawsuit against you and you owe statutory damages, is it something that insurance will cover or no?
Well, years back when these cases first started, there was coverage for these claims, but the insurance companies quickly saw how dangerous these claims were and how they're very hard to defend if you violate them, and the numbers rack up pretty significantly. So there's been a huge move, which every um, general liability insurance policy that I've looked at in the last, I would say, 10 years, specifically exempts claims under the TCPA because insurance companies don't want to get stuck with the liability. Again, that suggests this is very serious business, even though it seems not serious. It has big dollars attached. So insurance companies have dropped all the coverage for this. There are a couple specialty policies. So if you're engaged in this activity on a large scale, there are some specialty policies that will actually cover TCPA cases. Sometimes if you have media coverage or advertising coverage, sometimes TCPA claims are not excluded. So if you do get sued, first thing you want to do is really look at all your insurance coverages and see if you have insurance coverage. I would say 9 out of 10 times you're not going to have insurance coverage. Then the next path is really to look at your vendor contract if you're doing a vendor contract, see if you have indemnity rights, and then
Mhm.
go on from there to see whether it falls under any of the exemptions or other mitigating factors that would get you out of the claim.
Okay. All right. So this is a lot to take in, but I think, just to wrap this up, what we're saying to people is that there is this law out there. So if you've been using text and email to communicate with your patient, You need to be sure that you're getting their consent on file. You need to be sure that you're communicating in the proper way about the proper things that you're allowed to communicate about. If you're using a vendor, you need to make sure the vendor's on top of it and or honoring opt-out, confirming that patient information is accurate, up to date, and they have not opted out, and those kinds of safeguards. And most importantly, if you find yourself caught up with this, to immediately talk to counsel. I would say if you become aware of one mistake that you've made, to cease all further operations until you figure out what went wrong. Because if one thing went wrong and you don't correct it immediately, you might continue doing it and escalate the problem even further. Sometimes you can catch it pretty early, or somebody complains right away about something, and don't ignore it, right? That's kind
No,
of what.
I'm sorry, I don't mean to interrupt you,
Yeah,
but
no.
just on that, another thing that's very important, like, so if you get approached by a plaintiff's attorney in the form of a letter where they're saying that they believe that you violated the TCPA, I would strongly advise not contacting the plaintiff's attorney. Sometimes the thought is I'm going to reach out to them. I'm going to explain to them why this happened. It was just a mistake. There was an error in our software, and or some anomaly. But these plaintiffs' attorneys are very predatory, and they would love to engage with you and find out if you had a software problem, or if there was some type of a communication failure with your vendor or something like that, because it will then they believe that there's a class action, and that there's a much larger dollar figure to go after. So I don't think you want to provide them about any information about why failure occurred or why the text was sent. You need to be very careful about that, because they know they'll be fishing for specific information, which will alert them to whether there's a bigger case here. And the bigger cases, if they really think that there's a large scale violation, they're difficult to settle, because they know that if they push the case forward, um, they can get a very large judgment against you. So you want to be careful about how you communicate with anybody that is accusing you of a violation of the TCPA
Right. And I
violation.
think that would go for anybody who ever contacts you accusing you of anything, right? I always find doctors try to be helpful, and they call and they talk and they share too much information. Look, if you get a letter from somebody accusing you of something, talk to your own lawyer before you do anything. And I think that Mark is saying that advice applies here as well, right?
Good
Right.
advice. Good advice, Eric.
Doctors tend to be super friendly and always trying to want to work things
Right? They
out,
want
but
to help,
they
and
want to help.
the other
Yeah.
person on the other side does not want to help you.
Yes,
So
don't
be
help
aware of
them.
that.
Right, exactly right. All right, so any final thoughts on this topic?
Again, the advice that I always give to anyone that's involved in text marketing is you should know the rules, make sure that you're compliant, double check that you have all of the requirements in terms of opting out, you know who your vendor is, and that you don't um, ignore this, that you need to keep on top of it to make sure that you are compliant, and you should audit it on a regular basis. Because I've had so many clients that said, oh, I put everything in place and I did everything according to law. Then there was some breakdown and they didn't realize it. And it went for months and months and months, and they created a humongous liability for themselves. So you can't be passive in terms of, if you're engaged in text marketing or text communication, you really need to stay on top of it. You need to audit it. You need to make sure that you're always compliant. Because the worst thing is you find out that somehow there was a breakdown, and that you send hundreds or thousands of unauthorized text messages. Uh, Very
And you owe
dangerous.
millions of dollars in fines, right?
Yes.
Right.
I've
All
had it
right.
happen. That has happened.
Yep.
These cases are very serious in terms of the potential damages, which a lot of people think, oh, this is about nothing. But because of the fines, major companies like Bank of America have paid 40, $50 million on in claims for sending out notices, loan modification notices, and advertisements on refinancing. And they got caught up in this. They paid tens of millions of dollars on these claims. So they are serious. And these
And I mean,
guys,
if big companies with sophisticated IT departments can make mistakes, then certainly practices, especially smaller ones, are sure to make them. So it's not about, it's just mistakes happen, misunderstandings and breakdowns. So All right. Well, thanks for joining me today, Mark. I appreciate it. And if anyone out there has any questions about the TCPA, how to protect yourself, how to respond, please feel free to reach out. We're happy to answer any questions that you may have. And of course, you can email or call us anytime. We hope you'll check out some of our other podcasts that we've put out. This is the Health Law Hotspot, and we'll see you next time. Thanks.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.